Venkatramani, Senior Advocate, Dr. Vidrat Chakravarti, and all the participants. Of course, some of them may be even senior to me. I start with a sort of apology because initially I did not inquire in what context I am supposed to speak. Of course, speech is considered to be one of the most important aspects of generating ideas, and perhaps for the peace progress of any society. And from that point of view, I thought that I will speak on something, and some of the issues that currently are going on in the country may be of some relevance. So I thought of speaking on the issues relating to speech and sedition. But this reminds me the background paper which Venkatramani had just read out, and professor who gave the example of the Malaysian case, that would distinguish very clearly between a society that does not have freedom of speech and a society that has freedom of speech and expression. I am reminded of an Indian whose matter used to appear in the newspapers, one Dharampal. He was in England and practicing Hindu. He wanted his body to be burned after his death and not cremated even in the electric crematorium. And for that reason, he wanted a permission in advance that he would be allowed to do that. Initially he was not given by the authorities because the law of parliament did not allow it. He went to the court, maybe perhaps initial court could not give him the remedy. But when he went to the higher court, ultimately the remedy came. And the remedy came on the basis of those principles on which the laws in England have been interpreted for quite some time, that Parliament would never deny a right which a person has unless it is very specifically written that a person in every case, in every situation, will have to either be buried or cremated in a electric crematorium. And therefore, we grant permission to this person, Dharampal. Ultimately, he, of course, in his own backyard, was cremated by burning. Now, this difference, that a society where आपके लब बंद नहीं है, जहाँ बोल सकते हैं आप, and a society where that kind of freedom is not there, that makes a big difference. In some countries, particularly reference to United States was made, the language of First Amendment is similar as the language in most of the constitutions is. But so far as the scope of the right is concerned, that is unlimited. And limited in the sense that even the hate speech, though of course there are some discussions, but even hate speech cannot be punished or cannot be denied under the First Amendment of the United States Constitution. On this point, of course, discussions are going on that the hate speech actually create dissensions within the society, and for that reason, it should not be allowed. But for that, so far as the legal luminaries as well as courts are concerned, they have said that for that purpose, that for keeping law and order in the society, it is the responsibility of the government to ensure that the law and order is not disturbed. But so far as the speech is concerned, even if it is a hate speech, it should be allowed. Long back, generally, in this respect, that clear and present danger test, which was laid down by Justice Holmes in the beginning of last century. There, that Singh versus United States, where he said that unless and until there is a clear and present danger that a speech will cause, the speech should be allowed. And as a result of that, of course, the clear and present danger test actually was utilized for the purpose of putting restrictions on people with communist ideology during the after the Second World War, when there was a danger from Soviet Union that perhaps more and more communists are growing in the country, and there is a possibility that they might do the same kind of revolt as they did in Soviet Union. But ultimately it was realized that danger is not so serious, and even if it is so serious, the freedom should be allowed, and therefore the laws which were made during that time, they were slowly invalidated by the court. It is in this context that I had thought that one of the issues that has been going on in our country is in regard to the utilization or use of the provision relating to sedition, which provision initially, of course, was there in the IPC in Macaulay's draft of 34, but it was later on at some point was deleted and was not introduced initially when the Indian Penal Code came into operation in 1861. The provision, however, was introduced quite soon in 1874 or something like that, with an argument that this kind of provision should be there in the Constitution to stop those kind of activities in the criminal law, to stop those kind of activities, which of course are contrary to the orderly government of the time, that is, which are actually capable of upsetting the organization of the state. And that justification, of course, could be introduced at a time when there was no guarantee of freedom of speech and expression in the same way as it has been now provided under the Constitution. And there is a difference between having that guarantee in a Constitution, as I said about the American Constitution, that because of that guarantee they give it an unlimited scope. And because the American Constitution also does not have any exceptions to that liberty, freedom of speech and expression, or freedom of speech and press. Therefore, it can be exercised to any extent. Of course, as I said, there have been exceptions, but now they are not admitting any exceptions so far as that freedom is concerned. It is in this context that sometimes it has wider repercussions and relevance also. Quite some time back, there was a conference in Mexico, and it was on the concept of federalism. But at the end of this international conference of 2 days, I was asked to summarize the conclusions or express my views as to what that conference actually comes to. And one of my conclusions was that though it was on federalism, that federalism has a direct connection with democracy. In no country where there is no democracy, there is federalism. China is such a huge country, but it doesn't have federal government. Soviet Union created some kind of federalism, but it was not actually a federal state. It was a unitary state controlled by the party. And therefore, if you want to have a federal state, you have to have democracy. And if you want to have democracy, then it is necessary that, rather a precondition, that there should be a recognition of human rights. Without the recognition of human rights, democracy cannot survive. Now, so far as we in India are concerned, on getting our freedom when we set in writing our constitution, or even before that, in 1946 or earlier also, we had been demanding since actually 1895, we have been demanding inclusion of the fundamental rights in the constitution. And definitely in every draft or every demand, there was always the right to freedom of speech and expression included. And so therefore, so far as the people of this country were concerned, they were insistent and they knew that what is the importance of freedom of speech and expression. Also, it happened because of the consequences that took place in the absence of this right, as we know from trial of Tilak, Besant, and finally also of Gandhi in 1922, that people had to be incarcerated merely because they expressed their views, and the views were totally justified. Asking for liberty, asking for independence was not in any way something which should be contrary to any law or to any constitution. Though of course Britishers never believed in a written constitution, or even though they gave some sort of written constitution to India in the form of Government of India Act 1919 or 1935, they never agreed to include the fundamental rights in the constitution. They cited the example of Canada and Australia, that if people can have those liberties in those countries, they can have in India also. But as soon as we got the opportunity to make our constitution, we made it a point that, rather most important point, that we will have fundamental rights in our constitution. And this happened because we decided to establish democracy in our country. As we start reading from the preamble, that we, the people of India, resolved to constitute ourselves into a sovereign democratic republic, and that is why, therefore, it became automatic that if we are going to have democracy, naturally we have to have the fundamental rights of the people in the Constitution. Some of them are expressed in the preamble itself, but more details are there in Part 3 of the Constitution, which all of us are familiar. And it is there that Article 19 gives the freedom of speech and expression in its first clause, clause 1A. It is in regard to that clause, a question arose that whether sedition would be a ground for restricting freedom of speech and expression of the people. And because it had been a ground for restricting the freedom of speech and expression, therefore it was, while making the Constitution, it was not allowed to be an exception to the right to freedom of speech and expression and removed from the Constitution. But somehow the provision continued to remain in the Indian Penal Code or Penal Code, and it is continuing even today. And as a result of that, most of the political views which are expressed against the existing governments in the state or in the center, they are subjected to this law of sedition under Section 124A of the Penal Code. Now, it goes to the extent, for example, that recently some liberal activists, well known, all of them, they were subjected to arrest without there being a sufficient proof of what they did, but merely on the basis of doubt. And it is a matter of some satisfaction that now we have courts also, apart from a court which, of course, in course of time has become much more emboldened than the courts in the beginning of the Constitution. But from the very beginning, the courts had said that even if Section 124A of Penal Code is there, that section cannot be used for the purpose of expressing views against the government so long as they did not, or they do not create public disorder, or they do not lead to the creation of public disorder or some kind of sense of insecurity to the society. And unless it falls within the exception of public disorder or security of the state, that freedom is there to the people. And that must therefore be exercised by the people so long as in reality it does not amount to that, that cannot be subjected to any kind of freedom, cannot be subjected to any kind of restriction. However, time and again, people are being detained. And though of course in this case, so far as the court is concerned, it has given relief to these people, but there have been cases in the past like that.
No relief?
Yeah.
No relief was given.
relief, of course, at least they are not inside the jail. That in itself is
temporary. That is for longer period.
Yeah. Until, of course, because the police is taking the plea that they have the evidence. So, but they are not producing that evidence. Maybe
They are not produced. Courts are so weak in this country.
Yeah.
Courts have not
that
so.
interruptions with the rate of flow of the speaker.
My request, please.
We can ask afterwards. Sorry. I thought
I think
that
we
afterwards.
are little going this array. See, when the court is seized of a matter and the investigation is going on,
Flow of
we
speaker,
cannot
sir.
say
Any interruption will
whether
disturb the flow
something
of
is
the
there
speaker,
or
sir.
not. That will come and people will see that.
Sir, anyway, any disruption will.
Yeah, sorry for that.
No,
This
no,
last question.
Kindly don't
Yes, just finishing, but
No, we have not
I
asked
was
to
just,
finish.
no, I was just going to tell that in spite of that fact, in spite of the freedom of the speech and expression under the Constitution, and sedition having been removed from Article 19 exception, 19(2) exceptions, it is happening time and again. And more recently, that Vinayak Sen's case, who, because the lower courts actually do not give even bail to people. And until you get it from the High Court, it takes quite some time. And this is happening time and again in the country. I thought that this is one area which is directly related to political speech, which is part of the democratic process. And since we have established democracy in our country, it is absolutely necessary that that speech must be protected. And therefore, unless there are very clear circumstances that there is a danger to the government, the freedom of speech and expression should not be restricted in the name of sedition. Now the suggestions are coming that it is better to remove this section 124A of the penal code, so that there is no scope for exercising that power on the part of the police at all. Let us hope that the discussions will go on this issue, and perhaps we would be able to remove section 124A relating to seditious speeches. Thank you very much.
Questions?
So,
Questions now or afterwards?
so afterwards, let's finish this.
You have a
first.
format.
Yeah, we
You
have-
have a respect that.
No, I'm
Yeah,
just.
please.
we all have the right to dissent, but within the boundaries of the rules set by the. Thank you very much, sir, for your brilliant address. It's a total, very comprehensive address, throwing light on liberty and democracy and linking it with federalism. You rightly said that federalism is directly linked to democracy, and so is expression of speech and dissent directly linked with democracy. As far as section 124A relating to sedition is concerned, for our young students also, I would want to clarify that our penal code is of 1860. So we are living in a frozen in time 200 years ago. And everything needs to change. Slowly, they are removing sections 377 deleted, this deleted, 497 deleted. And what we need is a new penal code updated to our times, concepts of punishment, reformation, in addressing the needs of today. And as far as debate, discussion, candid thinking is concerned, I think there is total freedom in India, or there should be total freedom, because we have Article 19 gives us freedom of expression. So thank you so much for saying that 124A should be deleted. It's a view held by many. We all have the right to dissent, agree, disagree. And until, we hope that it is done by the political process rather than the courts intervening and again, enforcing the law and overextending the jurisdiction. आपने बहुत सही कहा, ये खामोशियाँ कब तक, जब तक तेरा घर ना बह जाए, आज बोल कि कल ये ना कोई कह पाए कि तेरे लफ्ज आजाद थे और तू ना बोला. Thank you very much. Now we had the painter.